State Fee Miller. I was just kind of retained, but I've kind of looked at what you guys sent me. I appreciate you sending me everything, but I know that you probably have a lot of people that you have to talk to in terms of the police officer and the victim. But in terms of this case, do you have an initial thought, or what are you thinking in terms of avenues on where to proceed?
Well, I've started talking with everyone, and obviously I know that the victim's parents are really upset about all of this. The police officers, obviously thought it was appropriate to file a charge. So at this point, I have some upset family members, and the public's kind of upset with everything that's been going on in schools lately.
Yeah, and I know that we've had some initial communication with the alleged victim, and I think her tale might be a little bit different than the parents, and I know that from your guys' perspective, you worry about her, but also I know the parents come into play, and just the fact that while he wasn't a teacher anymore, my guy does recognize he was in schools, and this was kind of a private lesson, but he still does coach at the school, and we know that's a concern for you guys. In terms of where we're at, I think there are some issues here on both sides, but my client and I, after talking to him, would be open to a resolution, and I think if we can come together, give you guys some options that you can take to the parents, take to the alleged victim, we would be open to try and get a resolution before trial. That's best for everybody. My guy, to give you some context, doesn't teach anymore. He works at a software engineer company. He's making good money there, so he just loves to coach tennis. His big thing is that he really only does two things: the video games and the tennis. While he kind of looks put together, I think he struggles sometimes socially, and I think that even when we read the text message or maybe even the interactions, they may have gone a little bit different, and I think she would tell you that it's portrayed maybe on paper or maybe to the parents. But his biggest concerns are still trying to coach tennis, and obviously to keep him out of prison and to limit any registration, but recognizing that you guys have to cover your bases as well.
So before I kick that hornet's nest and even start discussing a plea with the parents, I have to know what your guy is willing to take responsibility for.
Yeah.
What's he willing to plead to?
No, absolutely. And in terms of what he's willing to plead to, like I said, I think the charge is negotiable. Like I said, the biggest thing for him is that registration requirement in this day and age carries so much that would limit him. At the end of the day, he's a young man with no record, no history of anything like this inappropriate with, like I said, he coached for so long at the high school. This is the first time anything has ever come up. So,
That we've come up.
Well, I mean, I get that, I get that, but, I'll let you dig into the record and things like that, and we're sending over some polygraph stuff that you can look at. But, the biggest thing is something that requires him to register as a young person affects where he can live, affects where he could go back to school to continue an education or work. So that's our big thing, that to show, you, the victim, that this was perhaps not the best situation, but something that we could reform his actions. We could make sure that he stays away from her, make the parents happy. That's a deal that we could come to.
So are you thinking doing an information on a burglary or an aggravated assault with some time some other stipulations? What
would you be willing to take a stance on sentencing and registration?
We'd have to talk further about that. You'd have to get me.
Yeah, and I can go back and talk to my guy. The biggest thing is keeping the felony, like I said, felony and registration off the record. Something that, even if it's something as like a sex offender probation, that he would be more intensely supervised to show not only you but the parents, the alleged victim in the community, that this isn't who he is. That's something we'll be open to.
Okay, I'll discuss that with the parents.
Good afternoon.
Hi, how are you doing?
I'm doing well. Back here on the Miller case. So I know we talked last time, kind of basics, and you had expressed concerns with the parents. So I went back and talked to my guy. I know we briefly talked about his history, and so this is not someone with any sort of predatory past that we know of. He was in a position that was certainly awkward. Who knows about her? and he really enjoys coaching, but he is willing to give that up for a period of time to prove to you guys that this isn't something that he does, right? This was an awkward one-off thing that got really out of hand. And so our thoughts were given, I know your alleged victim is a little lukewarm on how things went, but it was consensual. We're not talking about a situation where she was forced, right? And so I think we do have somewhere we can meet where maybe both of us can walk away with this, where we can prove to you guys that he's not a predator and he gets that chance to prove it.
So obviously you hit the nail on the head. That's the state's biggest concern, and especially given the fact that he was a teacher and recognized that he couldn't do this and then took the step to be a coach thinking that he could do this. So what's your plan in having him prove to us that he's not a predator?
You can laugh me away, but I gotta ask, I told my client I would ask. We're looking for a misdemeanor, so no felony, no registration, but we're very willing to craft something on the back end with probation, 5 years if you want 5 years, intensive treatment, no coaching voluntarily, no coaching, getting away from all that to prove that this isn't an issue. So he gets the benefit of no registration and felony, and if he messes up, you throw him in jail.
Does he still have his teaching license?
He does.
Would he be willing to give that up as well?
I didn't ask that particular, so I'll go talk to him about that, but his main concerns are the felony and the sex registry. So again, we want to prove that this isn't what this was about. So I know he's flexible on things, but I'm going to ask.
Okay, well, let me know, and then I'll talk with the victim and her parents and see if we can come to a
But at first blush, not something you're saying no to.
Not something I'm saying no to, not something I'm saying yes to, but when you get me all the information, I'll definitely discuss it. But
I'll take that back to him. Thanks.
How's it going?
Hey, how you doing?
Doing well, doing well.
Good. Which one do you have?
The Miller case.
Miller. Okay. Yeah.
I don't know how much you know about the case at this point. How hands-on you've been with it.
I've got the file. I've reviewed it kind of briefly. I'm going to get discovery out here to you shortly.
Okay, great.
Yeah. So yeah.
Well, I thought it might be helpful as you're reviewing everything to kind of know a little bit about my guy.
Sure.
I mean, I know the first thing anybody thinks when any of us see these cases is, okay, we're dealing with some kind of old man pervert luring people to the Arby's.
Kind of looked that way, didn't it? Yeah.
Yeah. That's. I just want to assure you, my number one, he's 24.
Oh, is that right?
Yeah. He's 24. She's 17. So we're not talking about. I mean, I get it. Numbers are what they are, but not exactly opposite ends of the spectrum.
Okay.
My guy was very briefly for a couple of years. He taught Spanish at the high school, but he's not done that for at least a year.
He's not teaching at the school?
No, he is not. He's not teaching. He's actually he does software programming for video games.
Gotcha.
Kind of. I mean, to be perfectly honest, not your most mature guy. I think he spends most of his time with a headset on, or a tennis racket in his hand. Kind of good-looking young guy. These two played tennis together. He was doing private lessons when this happened. Just so you know, he's not real savvy.
The day that this happened, this was private lesson?
It was a private lesson.
Oh, okay.
And they went back to her house. So this isn't some guy that's bringing him back to his apartment where he has any kind of, some kind of a sex room or anything.
Okay.
This was, kind of a spur of the moment. I drove you home. And I'm not going to kid you. I mean, you'll see the text messages if you haven't already. There was some suggestion. I'm not trying to snow anybody on the fact that there was mutual interest.
Okay.
And I think if you talk with her, you'll find that she's probably lukewarm on seeing this guy get hammered.
Okay.
Quite honestly. And you know me. I'm a straight shooter. I'm not going to say a bill of goods about my guy. I'm having him take an assessment with Dr. Bassman. We're going to have him take a polygraph. This is not somebody with a history. You'll see that. I mean, I'm taking him at his word, obviously, but I don't know of any criminal history. And so I just kind of wanted you to get an idea of who you're dealing with from our perspective.
Yeah, no, I appreciate that. I'll take a look at it. Look, I don't know. It doesn't look great from the outset, but I appreciate the information. I'll take a look at whatever you got.
Well, I have a feeling if you talk to her, she'll be pretty candid with you about what she wants to see happen with this guy. And if we can get something done, that gives them the pound of flesh I need to give them, and some assurances that my guy's not going to be around her and not going to be around the school or teenage girls.
Sure.
I mean, I'll lock him in his room playing video games for the next 5 years. I mean, we'll keep him out of the picture.
Okay, I'll get the victim advocate in touch with her then.
All right, I appreciate it.
All right, thank you.
Hey, Neil, I'm here on that Miller case again.
Yeah.
And before we get into it, I know you and I have had a lot of, not even talking about the Miller case, but a more philosophical view of things. And I know you're the prosecutor, I'm the defense attorney, but when we get into this whole Marcy's Law thing, and kill me if I'm way off base here, but it always seems to me like prosecutors are willing to die on that hill if the victim wants the guy, torn apart. But if they don't, I mean, what's the deal? I mean, I'm getting the sense from this Miller case that your victim on the case is lukewarm at best and really doesn't want to push this thing. I mean, even my understanding is the mother even said she doesn't even want the guy to go to prison. What's driving this?
I think there's a couple of things. Public perception, obviously. We've got someone who's in the education system. Parents want to feel like it's safe to send their kids to school. They want to be able to trust these people who have their children when they're not there, right? We want to believe that our coaches have it best for our children. So I think that's public perception is huge. Yes, the 17-year-old who is getting attention from the older guy doesn't want him to get in trouble. Okay, we have daughters. Okay, so she doesn't want him to get in trouble because she thinks she's in love. She's 17. I don't know that I'm that concerned that the 17-year-old doesn't want her boyfriend to get in trouble. But, I mean, the parents here too, right? I mean, they want to know that, their daughter is protected, that there is punishment for somebody who breaks the law.
We know who's paying big fee here. I mean, so let me put that obvious card on the table. But, all right, yeah, we both have daughters. So hypothetically speaking, let's say if the parents in this case want this guy nailed to the wall, and that happens, and he's branded a sexual offender, and he's driven off in disgrace to ODRC, where does that leave her? I mean, honestly, so she's the one that didn't want this prosecution to happen, but it happened anyway. So she's told she doesn't know anything because she's 17. But when she goes back to school, and all of the members of the tennis team and all of her friends that knew Coach Miller are telling her, what have you done to jam this guy up? And we all liked him, and you were on board with everything, right? I mean, again, I'm not saying that I have any personal knowledge or statement from her other than saying that she didn't want to proceed with the prosecution. But what happens if this girl loses it if he goes off to prison? I mean, have you talked with the parents about it? I mean, is there some sense of that?
About whether they're concerned about their daughter. They're certainly concerned. I mean, I think they think she's already in a bad mental place because of what has happened. I think they share the same sort of parental, still, we know what's best. I can reach out to them, but I don't know there's a lot of leverage to be like, you're going to ruin your child, so you should let the sex offender go.
Oh, well, let me be clear. I'm not saying my guy walks. I mean, I get that they need some assurances, and I'm not even going to look you in the eye and say, give my guy a misdemeanor. I'm thinking more along the lines of, maybe an aggravated assault, some felony offense. If he's on probation for 5 years and he can't get expunged for another 3, that gives them 8 years. And if their daughter's 25 and is still interested in my guy, well, they probably show up at the wedding. I mean, tennis coach, computer programmer, but I've got to try and go back to my guy with something that's not going to be that permanent scar. And quite honestly, I think his permanent scar might not be the only one that's a result if we go out there and do something by way of trial.
I'm happy to talk with the victim's advocate. I don't know if this is going to get us anywhere, but I'll let the carrier pigeon go deliver any message if they're concerned about that. I mean, we always have to worry about juveniles when they're testifying, so I mean, that is a concern. Just mostly, again, emotional toll. She's going to have to see her guy. That gets hard. I don't know that I want to put her in that position if we can work something out where she still gets all the protections. I'm going to ask, we'll see what happens.
Neil, I've seen you sell a lot of things, so if you're interested in trying to get something done, we're interested in trying to work to get something done that hopefully gives them some peace of mind.
All right, give me a couple weeks.
Thanks. All right, well, I guess we're back on the Miller case.
Yeah, and I think we're working toward a potential resolution.
In case you don't remember, Judge, he's a 24-year-old guy.
He's a computer programmer. This all started because he was got a little too close with a high school tennis player.
He's got no record.
I think that there's some evidentiary problems. I mean, obviously, if we put this in front of a jury, it can be unpredictable. But as to the kind of letter of the law, there's not penetration here. It's not something where this is like a plea down from a rape or something like that. Not to minimize what Mr. Miller did, but he's a 24-year-old kid. Obviously, shouldn't have been making the decisions he was. We'd like to get somewhere where he's not registering as a sex offender. He's willing to take a lot of steps to show that he can be rehabilitated, that he's not going to be a problem for the state of Ohio in the future. But the main thing is that sex offender registration, and we're obviously hoping that he's not incarcerated for some period of time.
And to Mr. Wiseman's point, the issue that the state is having is the hesitancy of the victims who want to get on the stand and testify about this case, Judge. But obviously, we have our concerns with the fact that he was a coach employed by the school when this incident occurred. He previously had been a teacher and then knew that it was wrong to engage in this behavior as a teacher, but thought, I think if I become a coach, it's going to be okay. So, we have concerns with how he looks at young girls. Obviously, she's 17, but, as a teacher coach, he had access to girls even younger than that. And we understand that we're having some trouble in our schools right now with teachers misbehaving, so we want to send an appropriate message. And what we've been discussing is potentially a resolution to an aggravated assault. What we've discussed further, if the court would be amenable to this, is an agreement to 5 years community control with some kind of intensive probation regarding sex offender treatment, have him subject to random polygraphs and obviously a stay away order. Additionally, the state would be requesting that he voluntarily surrender his teaching license and that he not teach or coach anywhere near a school system.
I get that she may be wary. What are the parents? Are they looking for bear on this one, or?
So the parents aren't necessarily looking for prison, but they were hoping that he would be a registered sex offender. So in order to avoid some of the evidentiary issues that we can foresee going to trial, my thought was that we'd settle on a middle ground with the sex offender community control based treatment and keep an eye on him that way.
No local time or community-based correctional facility or anything of that nature that's been discussed?
We did not discuss that. I wasn't going to take a strong position in terms of incarceration.
And obviously, our position would be, I think that the court can craft a better probationary sentence without the use of local time or something like that, to really keep an eye on him and to allow him to be rehabilitated, through outpatient treatment or something like that. That would avoid, incarceration where he's not really rehabilitating himself.
So just so I'm understanding, are we talking about an agreed sentence, or are we talking about still a pre-sentence investigation with this sort of being the proposed outcome?
I think we would have a joint recommendation, but if the court's interested in seeing the pre-sentence investigation, then neither side would have an objection to that.
Okay, sure. Well, as you know, I'm not going to point my way to overturn what's a well thought out plea agreement, but I would like some peace of mind and at least seeing victim impact statement and a pre-sentence investigation. But as long as everything checks out, as I'm sure it will, I think that sounds like a resolution that the court could live with.
I don't think you're going to see any surprises, Judge.
Thanks, Judge.
All right, well, I'll look out there for the plea form, and we'll see if we can get through the colloquy.
Sounds good.
All right.
So that was different, and I'm curious to know what your thoughts are about that approach. when you would actually ever use it? What would need to be in place? I'm really curious to hear what you think.
Well, I would offer that we made it clear it wasn't our first pretrial. So we've talked about the nuts and bolts of this case. We've already had the discussions about what the facts are. I think it was pretty clear that we knew each other. First name basis, he knew I'm a dad, I knew he's a dad, he knew I had a daughter, I know he has a daughter. So it's a more personal connection. So not a conversation I would have had with just any prosecutor. So there were openings that allowed that kind of a discussion to happen. But because I'm not gonna, somebody that doesn't know me, like, look, this defense attorney came in and wanted to not only lecture me, but lecture the victim's parents on how to parent.
Yeah.
But if we're having a more just sort of theoretical discussion about what could happen and what the outcome might be, you know, we could get away with it with those things in place.
Any thoughts? If you were the prosecutor, how would it hit you?
I think it's hard when anyone tries to blame a victim in any sort of way, right? And to say, well, yeah, we need to patronize here, we need to protect the victim. If their parents don't know best, I know best, I think it would be hard. I think you'd really have to know the moment and really know the prosecutor to be like, yeah, but she's going to be traumatized, which I think, and has come up in conversation with others, like, yeah, because your guy did it first.
Yeah, lucky. My guy's so lucky, she's going to be traumatized, so
Okay,
I get less of a sentence.
So you're extending the same concept your client did. So I think you'd have to have a right moment with the right prosecutor to try that, especially because she's a juvenile. I feel like.
Yeah, so this is if edgy
Well,
at
she's
best.
17.
Well, I'm not sure.
I mean, you know, I wonder in Butler County where this case would go. I mean, the age disparity is not that big. I mean, it's just, I'm not saying that it's not check the box, a violation of the law, but we're talking barely toe in the water. I mean, he's not a teacher, he's a coach. There's not any text messages, at least in what we've been supplied, that said, you will give me a blowjob if you want to start in the match. I mean, there is not.
None of that.
There's none of that.
And there's equal flirtation
There's-
in the text messages that were
exactly.
really fun to write, just saying.
Well, and he's not real savvy. A
Right.
24-year-old that goes up to her room to make out while mom is at an appointment. I mean, if he's really grooming her and wants her to be able to do everything that he wants to do, it's going to be in a different environment.
He would have done a better
in my
job.
opinion. Yeah, this is more like the teenage boy getting
Yeah.
caught in the room, running out with your shirt on. Oh, I spilled some juice on it. I mean,
This is an amateur.
This is amateur hour. This is
Yeah.
amateur hour. So.
Would you ever
that's-
say that to him?
Sure.
It's kind of an interesting.
If I know
thought.
the prosecutor, and that's just it. If I know the prosecutor, I'll have those conversations. I mean, quite
So if this
honestly.
prosecutor had said to you, well, how do I know he's not a predator? And you said, you could say, I think this is amateur hour.
Yeah,
If you read his text messages,
Yeah, he read the text messages. He spilled juice on his shirt. He ran out without putting his shirt back on. I mean.
He would go home with her, wouldn't he take her somewhere?
Right.
He had already
Wouldn't
planned?
he take her? So I
Well,
mean,
there would've been
they're
like,
two young people. They're agile. They're tennis players. They could have done this in the back of a car. They didn't need to go to her house. I mean, it's.
Yeah, there was no coercion or like threatening,
No.
like don't tell anybody or this is going to
Well,
be
she
bad for
invited
me.
him in, I think. Yeah.
Right.
Yeah.
And you know, it's. I don't know that this one would be one that anybody wants to be the hill that they die on.
So you could characterize, you could do that with, once you know it's the case and you know the case and you know when we've got to know him, you could say, you know, this is amateur hour. It's not someone luring her, it's not a pattern, it's not a.
I'm going to tell the prosecutor, I will get a jury box filled with mothers of teenage sons or
Yeah.
older sons that have at one
Yeah.
time been teenagers or 24 years old. And I'm you know, when your witness walks up there, she's going to be my exhibit. I mean, quite honestly, I mean, this is not, a girl, you know, who's gonna say that she was intimidated by this guy, that she
Yeah, she's not gonna
didn't
say
welcome,
that.
that she didn't
Yeah.
welcome the text messages, and was there ever any attempt on his part to link, you know, her place on the tennis team with some romantic involvement? And by the time they get done with that, you can call it jury nullification if you want, but I don't think that they're gonna be hot to trot to jam this guy up.
Would you ever say that to a prosecutor?
Again, it depends on who
Yeah,
the prosecutor is, and that's why I say, to me, it's when are we talking about this case? If I'm talking to the prosecutor at preliminary hearing, you know, begging that they don't bind the case over, that they would at least consider, you know, talking with the victim and talking with the parents to possibly work something out where the earlier I can get the case worked out, the better. I mean, once a prosecutor's indicted the case, it becomes much more difficult. It's like, this isn't just the cop that charged it. I presented this at grand jury.
Right.
You know, now ideally, some other prosecutor presented a grand jury, and he's like, what in the hell was Brad thinking
Yeah.
on that particular day? You know, yeah, this is what happens when he covers my grand jury. You know, I get the hot tennis coach.
Yeah,
You know,
yeah.
that's who I get to prosecute. So I think, again, it depends answer. Who's my audience? How well do we know each other? I mean, quite honestly, there might be a prosecutor or two that my first terrible rendition, they would laugh and think it was hilarious.
Right.
You know, when we come in there and say, and they're like, all right, now I'll stop being fill in the blank of obnoxious defense attorney.
Right,
And
right.
now we can have a real conversation about the
Right.
case. I
Right.
mean, again, depending on who. I know what prosecutors have a dark, twisted sense of humor and what ones don't.
You know, this is really great.